So I believe we are already on YouTube.
Yes.
And I see we have also here Anderson.
Yes.
But the camera is not open yet. So just to let you know.
Did you recognize Anderson from doctorate? Our student.
Yes.
He has some experience in Islamic law.
By the surname, I inferred that, so.
Vou me dirigir, professor Jonathan, em respeito ao senhor, vou falar em português, ou o senhor prefere que eu fale em inglês? Eu estou presente, professor, por ter comentado com a professora Mariana, por ter vários assuntos ligados ao islamismo que eu já estudei. E aí, quando a professora Mariana comentou na sala de aula, ela convidou para participar. E eu tive a oportunidade de, em 2016, representar o Brasil na Índia, a OAB brasileira na Índia, num congresso dos BRICS. Então, a professora Mariana convidou para que participasse. Muito obrigado pela oportunidade. Mais uma vez, agradeço a professora e agradeço o senhor também por permitir a participação. Muito obrigado, professor.
Não, eu fico muito feliz. Aí eu tenho, enfim, a gente sempre se divide aqui em várias línguas, né? Porque tem de dar os avisos, tem de fazer tudo, tem de cumprimentar, enfim. Eu estava vendo e sua câmera estava desligada. Eu fiquei na dúvida se você estava ou não. Por isso que eu cumprimentei o Rafael, mas não lhe cumprimentei assim que eu cheguei.
Não, professor, agradeço a deferência. Eu mantive desligado até para não atrapalhar eventuais conversas da professora Mariana com o professor Imtiaz ou qualquer coisa do gênero, para não gerar nenhum incômodo. Muito obrigado, professor.
Jonathan, hoje você vai fazer a abertura, tá?
Formal. Aí eu faço em português, depois eu começo em inglês, ou como é que você quer fazer?
Como
e quem vai passar para a professora Maria Helena?
Eu.
Tá. Então eu falo português, inglês, e depois eu passo para você.
Isso, aí eu passo para o professor Imtiaz, depois a gente tem a participação da professora Maria Helena, e depois o professor Rafael, e depois do Anderson.
Tá. Deixa eu ver, eu já devo estar na tela aqui. Olá a todas e todos, eu sou Jonathan Barros Vita, coordenador e professor titular do PPGD Unimar, Programa de Pós-Graduação em Direito, Mestrado e Doutorado da Unimar, Universidade de Marília, e é com muito prazer hoje que a gente tem uma discussão que eu acho que é bastante interessante, digamos assim, dentro, obviamente, de uma perspectiva internacional e dessa ideia de um direito islâmico, né? Então, a gente recebe hoje, com muito prazer, o professor da Universidade de Patna, na Índia, Imtiaz Ahmad, e a gente discute hoje aqui com o Rafael, professor Rafael Costa, e temos o nosso aluno, né, o Anderson, do PPGD da Unimar, e, enfim, temos a Sinara, a professora Mariana e Diniz aqui estão também no Zoom, e vai ser uma discussão super interessante. Eu não posso deixar de dar os recados ainda em português, que não se esqueça de se inscrever no canal, clicar no sininho para ativar as notificações, curtir o vídeo, se inscrever no Instagram e no Facebook. E lembrando que hoje a gente ainda tem às 18 horas eventos dos professores Carlos e Walter, amanhã evento professor Elias e sexta-feira evento comigo sobre reforma tributária e normas anti-abuso às 18 horas, vai ser super interessante. E hoje eu saí, né, vou ter que falar isso, Mariana, que saí de uma mesa da Bahia diretamente para São Paulo, então fui recebido lá no Instituto Tributário da Bahia, com muito prazer, pelo queridíssimo amigo Diego Bonfim, e hoje e amanhã, gente, o PPGD Unimar está apoiando o evento do GTEX, então vejam as nossas redes sociais, vai ser um evento muito interessante de direito tributário, capitaneado aí pelo Paulo Caliendo, e vamos ter aí várias discussões. Dito isso, só posso dizer que é com muito prazer que faço essa abertura em português ainda, e agora vou começar a falar em inglês para nosso convidado se sentir bem recebido. So, hello everyone. I already stated in Portuguese, but my name is Jonathan Barros Vita. I'm the director and full professor of the Master's and PhD program of Unimar, University of Marília. And I'm really glad to receive another perspective on this project of Professor Mariana Santiago related to Islamic law. So it's a new approach to, I can say new approach in our event, because obviously Islamic law has been around for really a long time. And I believe it's really interesting to know these different cultures and different approaches to law. And we are receiving Professor Imtiaz Ahmad from Patna University of India. And I believe this will be a great event. And we are here alongside me with Professor Mariana, Diniz, Professor Rafael Costa, and Anderson, who is Jamil, who is a student of our PhD program. And also Sinari is always on the background. So really welcome everyone. Don't forget to subscribe on our channel, click on the bell, and like our video, and also follow us on Instagram and Facebook. And we will have many events today, 6 p.m., tomorrow, 7 p.m., and Friday, 6 p.m. So we'll be really happy to welcome you all on all those events also. Keep posted on our social media. Thank you, Mariana.
Obrigada, professor Jonathan, pelas suas palavras. É uma honra tê-lo aqui fazendo a abertura oficial desse evento. Eu falo primeiro em português para agradecê-lo, agradecer também aos nossos alunos. Professor Jonathan veio da Bahia para São Paulo, eu vou de São Paulo para o México ainda hoje à noite, professor Jonathan. Agora que você nos colocou nessa vida de canal do YouTube, né, só Deus, que é o assunto do dia, né, para ajudar a gente aqui a se salvar dessa nova rotina. Eu vou falar agora em inglês para que o nosso palestrante se sinta mais à vontade, mas se eu perceber qualquer pânico também na audiência, a gente volta para o português para resolver, tá? Espero que dê tudo certo. Hello, everyone. For those who don't know me yet, my name is Mariana Santiago. I am professor of the postgraduate program at the University of Marília. I hope you all are well and safe in these difficult times of pandemic that we are living. We will start now our weekly event titled Dialogues on Development, Company and Society. It's an event organized by the University of Marília for our students, but it's now completely open to all the law community. It was getting bigger, so now we have students all over Brazil with us. Welcome, everybody. It's a pleasure today to have with us Professor Dr. Imtiaz Ahmad from India. He was professor of Islamic history, medieval Indian history, and history of colonial Middle East at the Patna University before being appointed as the director. Now he is retired. He has published 5 books in English and 3 books in Hindi, besides more than 75 articles. It's really impressive. His lecture will be also about Islamic law, changing perceptions. The subject is extremely important, and it's in line with what we work at the University of Marília about human right to development. I would like to mention the presence today of Professor Dr. Rafael de Oliveira Costa from Catholic University of São Paulo, and the presence of our doctorate student, Anderson Abraham. They will discuss the topic with us in a dialogue. Thank you so much. And today, we will also have a special intervention by Professor Helena Diniz to send us an important message about the subject for our reflection. Thank you so much. Professor Helena Diniz, thank you for your generosity and for all the support for this event. So finally, I wish everyone a great event, and Professor Imtiaz Ahmad, feel free to start your lecture. We look forward to hearing you. Thank you so much once again.
Thank you for your kind words. Professor Mariana, members of the faculty, guests, and students. Good afternoon to all of you. I would be talking about Islamic law, or Sharia as it is called, and the changing perceptions about it. Perceptions that have developed over the past centuries. And I would also try to correlate it with some of the present ideas about the Sharia, which are very much in currency. Since the larger number of the audience is from the students, I would prefer to give a general introduction to the major points. And then, while interacting with the scholars, we can go for more details. I hope that would be helpful. So, I will start with the talk. I will read some portion of the text and then comment on. The Islamic law, or Sharia, is a comprehensive code, and it covers all aspects of the life of a Muslim, individually and also as a member of the community. It has three components: ibadat, that is religious rituals. I repeat, ibadat, religious rituals. The second is muamalat, and this covers a very broad range: polity, civil and criminal law, legal institutions and practices, taxation, interpersonal relations, and even moral conduct. Though in certain instances, moral conduct is treated separately under the title of ikhlaq. And the third is uqubat, that prescribes punishments. So these are the three major categories, and they relate to religious rituals, various aspects of civil life, and the punishments that are prescribed for the offenses. Now, the Muslims consider this law as a divine decree because its ultimate source is the Quran, which for the Muslims is a divinely revealed text. As such, they consider the Sharia, or Islamic law, as absolute and eternal. I would repeat, absolute and eternal. No part of it can be altered or nullified, but it can be interpreted and adapted according to specific situations. This law is different from the secular laws framed by humans that can always be reviewed, amended, or even abrogated. So that is the fundamental difference. Now, this raises the question whether Islamic law is static or dynamic. The different methods of interpretation and the instances of adaptation certainly show that the law is dynamic. The static perception is more of a notion, and this is important. Like all other law codes, the Sharia has evolved, it has been interpreted in different circumstances, different perceptions have developed. So this is the actual position, but theoretically, it remains unchangeable and final. So that basic distinction has to be borne in mind, that in theory, it remains absolute, unchanging, and this also applies in practice to certain basic ideas or certain basic concepts. I'll come to that later. But as a functioning system, it has undergone changes and accordingly, different perceptions have evolved. Another point that we ought to remember is that all the details regarding Islamic law and its practical application are not discussed at length in the Quran. These are gleaned from the hadith or the sayings of the Prophet, hadith or the sayings of the Prophet, and the sunnah or the tradition of the Prophet. These are therefore a supplementary source to interpret and elaborate the Quranic injunctions. Now, such interpretations that emerge from the analysis of the hadith or the reference to the sunnah is referred to as ijtihad. Ijtihad. This in turn is based on two elements. The first is consensus among the scholars of law. This is technically called ijma. The other is analogy. You infer certain facts on the basis of certain incidents or certain precedents that you have. And this is qiyas. At the same time, one has to take consideration of the fact that there is a subtle influence of Roman, Byzantine, and Judaic law, which has contributed to this process, though not in a very direct manner. Now, the interpretation of these fundamental sources have helped the evolution of Islamic jurisprudence. And over a period of about 400 years, to be more specific, about 2 centuries, that is between the 8th and the 9th, these interpretations gave rise to 4 major schools of law, or you may call them sub-schools. These are based on Islamic jurisprudence or the fiqh. Now, the 4 schools of law that I am referring to are followed by the Sunni Muslims. They constitute the overwhelming number of Muslims all over the world. A 5th and a later school emerged by the 11th century, and this is followed by the Shias, a rather small dissenting group. It is generally maintained by the large majority of the Muslims that the interpretations of the 4 Imams is final and needs no further review. But then there is one particular school of law which maintains that these interpretations can be reviewed, can be re-examined. So I'll come to some of these details. Now, the 4 schools that developed are identified with the Imams or the expounders of law. The first of these was Imam Abu Hanifa. Imam Abu Hanifa. His opinion is quite liberal, and his followers constitute the largest group among Muslims. The second was Imam Malik. His views were more orthodox. The third was Imam Shafi, who tried to strike a balance between the two predecessors, and his views are more moderate. There is a 4th school also, identified with the last Imam, that is Imam Hanbal. This is the more orthodox among the 4. And this is the school which believes that ijtihad or interpretation is a continuing process. Now, incidentally, the ideas of Imam Hanbal have inspired various fundamentalist movements, the latest being Salafi Islam. And these views have also been arrogated by certain groups in modern times who believe in violence and aggressive conduct as a means of political protest. But that requires a separate discussion. We may go into some of those details during the interaction. Then I'll move on to the three facets of Islamic law, which I have mentioned earlier. The first, as you might have noticed, is ibadat. These are the core content, and these have not changed over the past several centuries, nor can they be changed. The obligatory profession of faith and the prayers and the fasts and other those rituals. Now, the Islamic, quote unquote, state, I'm not referring to the present concept of the Islamic state, I'm referring to the past. Because, if you talk about the Islamic state in the present context, it can lead to so much of confusion. So, referring back to the past, the Islamic state, and I put Islamic within single quotes, had the power and authority to impose these rules of conduct and punish the offenders. A renegade could be executed. And these matters related to ibadat, were treated under a separate category also when it came to matters of punishment. And this was called the hudud. Theoretically, these were considered as crimes against God or Allah. Now, obviously, these measures cannot be implemented now under the modern law. But in the past, this was a practice. Then I move on to the second theme of Muamalat, and I begin with polity. Because polity is one area where there has been considerable change, very palpable changes, and these changes have given rise to different perceptions about Islam. So I'll take this up in slightly more detail. Well, since its beginning, Islam represented not only a faith, but also a state system. Following the demise of the Prophet in 632, the leadership of the community devolved upon the Khalifatul Rasulullah, or the successor to the Prophet of Allah, more correctly, or more commonly rather, referred to as the Caliph. Now, this early form was of a simple polity, largely inspired by tribal precedents, with a quasi-republican nature. I say quasi-republican because the Caliph was chosen by consensus, a consensus of the elite of Medina, the capital city. Now, this form of polity continued for about 3 decades. Changes followed, and there were reasons for it. The period that I referred to witnessed the expansion of the Islamic or Arab state in the neighboring territories of the Byzantine and Sassanid empires. The political ideas, theories, administrative institutions, and practices of these two great imperial systems penetrated into the simple political system of the early days of Islam. Moreover, this period was also marked by the rise of dissenting groups and schismatic differences, even divisions. The republican principle was replaced by dynastic rule. The capital was shifted to Damascus in Syria, which was formerly a part of the Byzantine Empire and naturally was a source of many new influences. Umayyad rule, therefore, witnessed adjustments with new situations, and a different perception emerged about the Sharia, a perception that varied from the earlier one, which was current in Medina or in the adjacent Arabian Peninsula. By 750, the Umayyads were ousted by the Abbasids. The capital was transferred to Baghdad in Iraq, a former province of the Sassanid Empire. So these were the two sources which I mentioned earlier, and these influenced Islamic polity in a decisive manner. especially in the case of the Sassanid Empire. The pre-Islamic Persian influences led to the rise of and consolidation of absolute monarchy, which was further endowed with a quasi-divine character. Now, this was fundamentally different from what had been there in the earlier days. But these new ideas, these new norms were readily accepted. It's true that a small group of persons maintained that these were not in conformity with the Sharia, but the greater majority accepted these changes. The Abbasids were finally overthrown by the Mongols in 1258. Then from the 13th to the 15th centuries, several large or small regional kingdoms appeared in the Islamic lands. Their rulers tried to ensure a harmony between the Islamic law and the local traditions and practices. A new category of secular laws, secular within quotes, were framed, which were, quote unquote, endorsed by the theologians. I'm referring to a particular example from the Indian subcontinent, an area with which I am more familiar. A new category of laws emerged, which were called Zawabit, Z-A-W-A-B-I-T, Zawabit, or regulations that related to political and criminal offenses, taxation, and the military organization. So these were major deviations from the traditional Islamic law. And although these were implemented, the fiction of the supremacy of the Sharia was maintained. So we have a rather dichotomous situation where in practice, the Sharia laws are being interpreted, at times circumvented, a more liberal attitude is developing, and yet the perception of the Sharia being unamendable or being unchangeable is theoretically maintained. Then it was not until the 16th century that a new political order emerged in the Islamic world. It was marked by the almost simultaneous rise of four great empires. The Ottoman from Eastern Europe to West Asia and also extending into a major part of Africa. The Mughal in the Indian subcontinent, the Uzbek in Central Asia, and the Safavid in Iran. The Ottomans asserted their status as caliph, but this was rejected and almost with contempt by their rivals. It was towards the end of the 19th century that the Ottoman Sultan, ruler, Abdul Hamid II, vigorously revived the claim for loyalty of all Muslims for the Caliph or the Ottoman Sultan. It was more of a political counterpoint to European, particularly British, interference in the affairs of his dominion. Significantly, the support for the Caliph was most conspicuous, most assertive in the Indian subcontinent, which was the British colony with the largest Muslim population. And in this case, some of the resentment against British rule also added to the base of support enjoyed by the supporters of the Caliph. To continue further with the Ottoman Caliphate, with the defeat of Turkey in the First World War, fundamental and far-reaching changes occurred in that country. Kemal Pasha established the first republican, secular, and modern state in a country which had a virtually complete Muslim population. And more importantly, he abolished the caliphate. Western impact and reforms in the colonial period also led to certain changes in Islamic law. The culmination came in the post-colonial period as several Muslim countries emerged as independent modern states. The supremacy of Islamic law in political matters was replaced by that of the constitution. A major exception being the Kingdom of Saudi Arabia, where an absolute monarchy continues to function and it adheres to the rules of the Sharia. In some other countries too, in more recent times, certain features of the Islamic law have been revived, largely due to the influence of fundamentalist groups. And the recent attempts in West Asia and in Afghanistan to enforce the Sharia were too brief to be of any consequence. So that again remains the situation. There are two parallel systems, the modern legal system based on European law codes and the traditional Sharia, which is more of a theoretical proposition rather than a practically functioning system in many countries. Then we can take up the second theme after polity. And this would cover civil law. This is the most elaborate and conspicuous feature of the Sharia. It relates to various matters, family, interpersonal relations, marriage, even polygamy, divorce, alimony, inheritance, bequest, etc. It also covers matters regarding contracts of sale, debt, hire, loan, gifts, partnership, etc. Yet another important component are matters related to land ownership, proprietary rights, taxation, and the public treasury. Now, to take some of these in some more detail, marriage in the Sharia is a social contract between two adult and consenting individuals. It is not a lifelong relationship in certain cases and can be terminated through divorce. This can be either unilaterally or by mutual consent. While some schools of law allow unrestrained right to the husband to pronounce divorce, at least two schools lay down conditions for it. So here again, we have the question of different perceptions. How do we interpret it? Whether the absolute rights accepted by certain schools is more applicable or the one which is an exception under the two other schools. Normally, the practice is that the more rigid view has been endorsed by the majority community among the Muslims. But then changes have been taking place. The terms of bequest and inheritance are also clearly stipulated. But again, the interpretations of the different schools vary. The right of making a will is allowed to a person, but some jurists maintain that there has to be a valid reason for it. As a further extension, the person can make an endowment of part or whole of his property for charitable purposes. So technically, this is called waqf. Now, while such instances are somewhat uncommon now, the existing endowments are maintained, often under the supervision of the government. Turkey, of course, is an exception. Now, for settling the claims of inheritance of the property of a deceased person, the first priority is to repay any loan that he might not have paid back in his lifetime. Then the terms of bequest or will have to be fulfilled. The remaining part is shared among the relatives, and the share of each of them is fixed. To put it very briefly, the son inherits twice the share to which the daughter is entitled. So this has been a matter of criticism in some quarters. So the son inherits twice the share to which the daughter is entitled. The surviving spouse and parents also get a fixed share. In case the deceased is succeeded by daughters only, their collective share is 2/3 of the total. The rest is divided among other relatives in the male lineage. I repeat, the male lineage. Their share is also fixed. Now, eldest property which nobody inherits, would pass over to the state and was, in the earlier days, deposited in the public treasury. As I just said, some of these provisions have been strongly criticized by modern progressive reformers. A strong point of criticism has been the discrimination against women. The focus being mainly on polygamy, differential rights in matters of divorce, absence of any provision for alimony, discrimination in matters of inheritance, etc. But the orthodox elements have tried to justify these on what they consider to be, quote unquote, logical grounds. They also highlight, with some justification, the fact that the Sharia allowed women to inherit and own property, conduct commercial activities, bequeath and gift property, and make endowments. They also enjoyed, even under the earlier dispensation, the right to obtain divorce. Now, these were certainly progressive acts in those times. But the question is, how far are they equally important or relevant in modern times? And to what extent changes are necessary? Now, as for the discriminatory provisions, one view is that some of these had a contextual relevance, and that has been lost with the changes that have occurred over the centuries. For example, it has been argued that slavery and concubinage related to a situation which was for the settlement of war captives, and naturally, they are no more valid. Although, in the medieval times, with the passage of time, the two institutions were distorted by the affluent and powerful. And again, I would say that though these were very clear deviations, I would even say violations of the norms laid down in the Sharia, these were accepted. But thankfully, the most satisfactory fact is that these are now finally abolished. Then the matters related to family affairs, some of which I have already mentioned, were generally not interfered with by the colonial rulers in their respective territories. These were classified as personal law of the community, and were implemented under their legal system. And in some cases, the practice has continued as a parallel arrangement along with the modern legal system in certain Muslim countries, or even in India, which is a secular country. The first and most powerful initiative at reforms in the family laws, again, came under Kamal Pasha. And the reason was very obvious. Having founded a secular state, he was free to proscribe or alter the provisions of the Sharia. Interestingly, his major reforms related to women. Polygamy was abolished, and divorce by court action was introduced. The husband's unrestrained power in matters of divorce were curtailed, and women were given extensive rights to divorce their husband. Civil marriages were made compulsory, though by later relaxation, traditional marriage was allowed to those willing for it. veiling of women was proscribed. Women's presence in public domain became conspicuous as they could take to education, employment, enter the civil services, health services, and other public engagements. Now, as early as 1929, and this is interesting, I suppose, the first beauty contest was organized in Turkey. It was a taboo in other Muslim countries in those days. By 1930, women got the right of franchise. They could get elected initially to the municipal committees and finally to the parliament or the Grand National Assembly. Now, though not formally acknowledged, Kamal's reforms provided a model for similar changes in other Muslim and even non-Muslim countries. Then to take up another theme, and I hope I have not been taking much time, mercantile law is not a distinct category in the Islamic law. It's part of the Muamalat. Now, all business transactions, sale, mortgage and purchase, gift, bequest, debt, loans, terms of partnership, et al., are preferably to be recorded in the presence of witnesses. These are to be recorded in the presence of witnesses. And these served as evidence in cases of dispute. But these were not always maintained in practice. In other matters, as per the customary arrangements, the disputes are adjudicated, decided by the Qazi. Trade is favored, even encouraged, and profit is sanctioned, but not profiteering. Usury is strictly prohibited, so much so that the Orthodox abstain from taking the interest paid by banks on their deposits. In recent days, some Muslim countries have experimented with the idea of interest-free banking. Taxes on commercial goods as sanctioned in the Sharia are almost the same as taxes levied for state charity. Taxes, again, are categorized either as religious or secular taxes. The main religious tax is zakat. It is levied on personal property, normally gold, silver, stock of grains, animals and herds, provided these have remained in possession of the person who has to pay the zakat for more than a year. Must have remained in his possession for more than a year. The rate is very low, 1/40th or 2.5% of the value of the entire possession. There is another relaxation. A person below the line of nisab or the taxable level of property is exempted. But the tax is mandatory. As per the Sharia, it has to be imposed, if necessary, forcibly by the Qazi, who is the religio-legal official. The amount collected is deposited in public treasury and is used for financing charitable and welfare activities. Now, significantly, this is one tax where the rate has not changed. It has remained the same. But its scope has been extended to include cash as well. In the earlier period, cash was not included. But now, cash is part of the possession or the property that comes under zakat. There has also been a difference in the mode of collection. Since there is no provision of Islamic state, this is not imposed under law, but is voluntarily given as an act of piety or religious merit. Now, in such places where the community leadership, remember not the state, but the community leadership provides for a public treasury, it is paid into it. Otherwise, it is disbursed through personal charity. This is different from alms giving. which is not mandatory. Among secular taxes, the most important is kharaj. This was levied on land and also on merchandise. In medieval times, it also included tribute received from subordinate rulers or people. Now, as early as the 7th century, a distinction was made in the land revenue between ushr and kharaj. And later, the same distinction was made between those the Muslims who owned their land, and this was the ushr or 1/10, and the non-Muslims who were landowners at the rate of 1/5 of the produce. So in other words, the Muslims paid almost half of what the non-Muslims paid. The kharaj on merchandise was 1/40th ad valorem for Muslims. It was higher for the non-Muslims, and in India, the Hindus paid twice that amount. Now, these provisions regarding land revenue and the tax on merchandise and so many other minor taxes have been fundamentally altered by the rulers in different countries and periods down the centuries. But again, the formal adherence to the Sharia was always maintained in theory, or let me add, it was more of a fiction. Other secular taxes were jizya or poll tax and the ghanima or war spoils. Both have become redundant in modern times. Now, these instances further show that Islamic law is not static, but open to different circumstantial adaptations. And then finally, to criminal law. This relates to offenses like murder, theft, banditry, highway robbery, usurpation, and so on. Matters which are related to ethical and moral conduct also were treated as part of criminal law. For example, adultery, fornication, false accusations, gambling, wine drinking, and you certainly know that wine or intoxicants are prohibited for the Muslims. Such matters were normally reported by the muhtasib, an official who is defined as a censor of public morals. But these were decided by the qazi. Gradually, many of the criminal activities like murder or theft or highway robbery came under the jurisdiction of administrative officials. The qazi's jurisdiction now ceased. As a different category, political offenses like rebellion, treason, conspiracy against the ruler came to be treated as a separate category. The king, or in some cases his representative, pronounced judgments on these matters under laws that were related to siyasat or political offenses. The mode and extent of punishment was at the discretion of the judge. Islamic law prescribes very harsh punishment for criminal acts, but with the objective of ensuring deterrence. There are certain mitigating conditions also. For example, a murderer has to be beheaded, but there is an option where the aggrieved person, the person whose relative has been murdered, can pardon the murderer or claim blood money or vergil from him. In that case, execution is not done. Now, imprisonment as a mode of punishment is not specifically mentioned in the Quran or the Hadith, and this is interesting. But the different imams, the expounders of law, have permitted it. Again, a matter of different perceptions. It was also a common practice in Muslim states since the pre-medieval times to punish people through varying periods of imprisonment. Now, to refer to the legal system, and that would be the last point for me, I think I have taken much time, but I'll now try to conclude. The legal system was simple yet elaborate. The Qazi was the apex authority. He decided matters pertaining to civil law, moral turpitude, and certain other crimes. He also coordinated with the officers who looked after cases pertaining to criminal matters. He was assisted by the Mufti, M-U-F-T-I, who gave opinion in the light of the Islamic law in specific cases. Now, such opinion was called fatwa, and fatwa was very often a basis or even a precedent for deciding cases of identical nature. The Qazi was also the head of the Department for Religious Affairs and Charitable Activities. In that capacity, he held charge over all religious endowments and recommended financial aid and support to the deserving. He was often a state official, and under two important empires, Ottoman and the Mughal, he was virtually a paid state employee. Now, that institution is practically non-existent now, but for a token presence in some countries where the Sharia courts or the courts that follow the Islamic law have been retained. There was no organized police system. The army normally maintained law and order. There are references to spies and to an officer who looked after various matters, including law and order, in the important cities. In his absence, that responsibility also devolved upon the Qazi. Then to sum up, Islamic law is based on certain divine ordinations, interpreted according to human reason and circumstantial needs. I would like to repeat this. Islamic law is based on certain divine, within quotes, ordinations, interpreted according to human reason and circumstantial needs. These interpretations often vary in matters of detail and reflect different and changing perceptions. These different perceptions have gained greater significance in modern times, when a parallel secular legal system has been accepted in most Muslim countries. While the progressive view favors such changes, the orthodox criticize these as deviations. Now, this is a continuing debate, and the more it advances, the changing perceptions on Islamic law acquire greater variety and complexity, more complexity as they evolve. So this is the point where I would like to conclude. Thank you for your attention. And I would also thank Professor Mariana for giving me this opportunity to speak to you. And I am also thankful to my young friend, Pratyush Kumar, who made this possible, because he mentioned, perhaps he suggested rather, my name to Professor Mariana. So thank you all very much. And if there are any questions or any points to discuss, I am here with you. Thank you once again.
Thank you so much, Professor Imtiaz, for your brilliant lecture. It was so impressive, so interesting. I feel sorry for the noise from my neighbor. Times of pandemic. Times of pandemic. It seems.
If I'm not interrupting you, I'm very thankful for your kind words. Please.
Thank you so much. It's an amazing opportunity for our students and for all of us. And now we will have the participation of Professor Maria Helena Diniz with some message in Portuguese for our students. And after that, I will read some questions and considerations for you, okay? Because the subject is so new for us and we had lots of doubts about it. Professor Maria Helena Diniz.
Boa tarde a todos os participantes deste evento semanal da Unimar, que tem muito contribuído para a cultura jurídica poder estar aqui com vocês, repartindo minhas reflexões sobre direito islâmico. É uma honra muito grande. Recebam meu carinhoso abraço e minhas preces para que Deus proteja vocês todos, hoje e sempre.
Thank you so much, Professor Mariana Diniz. Thank you, Jaqueline Zanettoni, for all the support. Eu falo agora um pouco em português também, para que os nossos alunos entendam a importância de ter o apoio, a participação da professora Maria Helena Diniz, que é a maior jurista brasileira, conosco hoje neste evento. É uma honra imensa e gratidão eterna, professora, por todo o apoio a esse evento. Vamos às questões. Eu já estou atrapalhando português com inglês, já não sei mais o que falo. E o meu vizinho segue com a obra, atrapalhando a minha fala, mas vamos lá, vamos tentar. Em inglês agora para o professor Imtiaz entender. I greet the entire legal community in the people of Professors Imtiaz Ahmad and Jonathan Vita. Participating in this event honors me very much. I apologize for the fact that my observations are being read for Professor Dr. Mariana Santiago, since I do not deal with technology. By studying Islam, some reflections emerge. If the norms of Islamic law are prescribed by God legislator, such norms would be unveiled by the human beings through exegesis from religious sources, or the function of legal science would it be to create norms taking as parameters the sacred sources and the current valuation in society? This is a question. Given this, would there be a possibility of adapting Sharia to modern times and new social situations? Could doors be open to admit a range of interpretative possibilities aimed at an analysis of Sharia based on valuing economic and social development of the current world before the divine and timeless nature of its source? What would it be the hermeneutical restrictions to do it? Are there rules that, despite not being part of the Sharia set of rules, work in parallel to keep up with the evolution of time and social progress? In a world in which the distances between countries and human beings are reduced, allowing the connection between borders and the impacting sin of countless people freeing their nations in search of a better life, the possibility arises that private situations involving Muslims are appreciated by foreign courts, raising some controversies such as to apply Sharia or not, how to prove and how to interpret Islamic law if the rule of private international law indicates its application, or if there is a contractual clause requiring its application, to recognize or not the effects of decisions, if any, based on Islamic law. When a situation involving immigrant or refugee presents itself to Muslim judge, would he apply Sharia or foreign law if there is conflict or incompatibility between Islamic law solutions with constitutionally protected fundamental rights and international treaties? What will be under Islamic law the connecting elements which would point out the applicable law if such conflicts occur in a Muslim country? If Islamic law is not elaborated by state or by man, it will it will have applicability in any territory where Muslims are, since they must observe Sharia in their relationship with God and with other human beings in the family, social, and economic relations. If Islamic law is a non-temporal and non-spatial legal order, since it cannot be disassociated from the profession of faith, the Muslim must be loyal to it and overcome any other social political connection, since God does not know the boundaries created by man. Would it be possible to talk about transconstitutional dialogue or interaction between legal orders, if one of which is Islamic? Would the progress of universal human rights violate Islamic law or not? How to seek a culture of peace, respecting not only different religions, race, traditions, but also fundamental rights and human rights. It would be under Islamic law, the control of migratory crisis through the consolidation of international solidarity and the demand by the non-governmental organizations and United Nations of an attitude of country of origin, so that it's possible to find the lost homeland on par of refugees, guaranteeing the continuity of life.
Perdão, professora, desculpa interromper, mas parece que o professor caiu, ele não se encontra na sala.
Nossa, é verdade.
Foi o professor Rafael que me alertou.
Eu mandei uma mensagem para você, Mariana.
Sim, eu estava lendo as perguntas da professora.
Está entrando, olha, está conectando. Ai, que bom.
Obrigada, ainda bem que você falou aqui, Sinara, porque eu estava
lendo. Foi o professor Rafael, deu os créditos a ele. Obrigada, viu, professor?
Muito bem. Hello, Professor Imtiaz. I think we had some problem here. Did you hear the questions and considerations for Professor Maria Helena Diniz? Professor Imtiaz, is everything okay?
Can you hear me?
Yes, now I can hear you.
Sorry,
but I think we had some problems with the questions.
Yes, there was some problem.
Okay, I can read.
I could not hear Professor Diniz, and as it was, probably she was speaking in Portuguese and I was unable to follow it, then I could not get the question. So if it is not inconvenient for you, could you very briefly tell me about the question so that I can respond?
Yes, there's in fact lots of points that that it's important for us to understand, and I can summarize it. The most important, it's a kind of hermeneutical question about how to conciliate the international law, public and private law, with the Sharia that is so important for Muslims. And how it's possible for a judge outside an Islamic country to apply it, because we have all the constitutional orders to face. And if in another case, if we have a situation in a Muslim country with a person that is not Muslim, how it's possible to apply all these questions? It's so important to international law, and we have some problems about the universal human rights, and we have some doubts about if it's possible to conciliate it, because we have a global evolution, but these religions questions is so fundamental to Muslims, and we want to know if you think it's possible to change it, to have some kind of unification, a global conscience. It's something like this, because we talk a lot about solidarity, but we don't know if it's possible to have a universal, a global solidarity. If we have so many different cultures and religions, situations to conciliate. This is the point. It's a little so many.
So can I now go ahead with my response?
Please,
Okay.
let us know.
Now, a few things that I could note down where I'll start with the last one. How do we reconcile between the different cultural traditions when we talk about universal solidarity? How do we manage to bring about this solidarity in spite of the so many sort of pluralistic traditions that we have? Now, this to me appears to be both desirable and possible, because solidarity does not mean bringing about absolute uniformity. Solidarity is mainly a question of understanding and appreciating each other. I would like to give you an example, say from India. Again, I say I'm more familiar with things here. There is a very famous expression in India, unity in diversity. And that has been the tradition in India down the centuries. Of late, however, this has come under some strain. But I do believe that saner views will prevail. I can say that for the world community also, that this solidarity can be achieved keeping in mind certain universal humanitarian values, many of which are shared by the different societies, by the different cultural traditions, and we need to build upon that. Perhaps a more effective way would be to initiate a dialogue which may take time, but will certainly create a better awareness and even a better appreciation of these different traditions that we have and which we try to, in a way, reconcile with each other. Because reconciliation is possible only if you can understand and appreciate the differences. So that, I think, can be a practical position. And theoretically, again, solidarity, to me at least, does not mean enforcing absolute uniformity. So the differences will be there. That was one point. The other that I noted down was about any disputes that may come up between a Muslim and a non-Muslim. Which law would be followed in that case? This, to me, is a rather hypothetical question. It can be answered in two ways, or rather at two levels. One is that in the present position, the law in most of the countries, I do accept that there are a couple of exceptions, but in most of the countries, the law does not maintain any such distinction between a Muslim or a non-Muslim. As citizens of the state, they enjoy equal legal rights. Exceptions can always be there, and I'm not going into that at this moment. I'm referring back to a situation which perhaps will give you a more direct answer. In medieval times, and I again would take the example from India, there was this provision that if one of the persons involved in the litigation was a Muslim and the other was a non-Muslim, then the Sharia will be applicable. But then that is a thing of the past. Now the situation has changed, and I just said we have a uniform set of laws for all citizens. So this is more of a hypothetical question, at least to me. Then I think there was a question about a judge in Islamic country, how would he decide a particular case? You see, in matters of criminal justice, I think the Sharia code is not a very effective instrument nowadays, except again for, I can cite the example of the Kingdom of Saudi Arabia, or what was done for a very brief and I would call that unfortunate interlude in West Asia or in some other parts of the country. Otherwise, the Sharia laws do not apply in the other Muslim countries. The other question which rather I was thinking of was that how do Muslims accommodate themselves or adjust themselves with that different social and legal system which they are exposed to either as migrants or as second generation migrants. You read so much about certain issues become a major issue. For example, the use of the hijab by women and so on and so forth. There, at least to me, and let me confess that I'm not a religious scholar, I'm talking more as a layman. But to me, I think the supremacy of the law should prevail, and it does prevail. So when you live in a particular country, you have to follow those rules or the law which that country follows. You may enjoy certain privileges, but those privileges should not be treated as a matter of right. And certainly, these should not come in conflict with the law of the land. I think that is how the response of Muslims living in certain countries, of course, which follow the modern laws, which are not subscribing to the Sharia law, and where certain problems come up. So there, I think the saner course would be to follow the law of the land. And I think most of the Muslims do that. Of course, there will always be a dissenting minority. We cannot rule that out. We have to accept that. We have to accommodate that in whatever way we can manage. But if you go by the majority, if you go by the dominant trend, this is the situation that Muslims living in countries, and even in Muslim countries, Sharia is not followed everywhere. So they accept the law of the land. So that is another point which I thought was raised by a person. Then there was the question of a conciliation between the Sharia and the changing circumstances. Now, in the talk that I just gave, I tried to highlight this particular issue, that there has been a continuous process of reconciliation between the theoretical position under the Sharia and the existing circumstances. I refer to the changes in polity. I refer to the changes in matters of criminal law, civil law. I refer to the reforms that have brought about major changes in the status of women, and so on and so forth. So that process of reconciliation has been going on, not only in modern times, but even in pre-modern times. Now, the extent of that reconciliation would differ. Under modern circumstances, one distinction that I can draw, under modern circumstances, it is the legal, the law or the legal code, the modern legal code, which will enjoy precedence. In medieval times, it was the Sharia that enjoyed a precedence. So this was a delicate balance. In earlier times, reconciliation was there, but somehow or the other, the supremacy of the Sharia was acknowledged, even if that was a fiction, but that was never denied. You could maneuver within those limits, but then you accepted that as a sort of, those parameters were accepted. In modern times, that acceptance is not there. And it is not there because the circumstances have changed. You are very rightly talking about universal solidarity. So we are living in a global community. And if we live in a global community, we have to reconcile ourselves with the different trends. And what I think is necessary is for the Muslims to appreciate this fact, and also for the non-Muslims to appreciate this fact, and to the extent possible, bear with the sentiments of the Muslims. That I think would be all that I can suggest. That I can.
Thank you so much, Professor. To clarify this point, these points for us, it's so important to our culture to understand how it works for Muslims. I think it's the best way to get peace, real peace in the world. So let's hear Professor Rafael Costa for his considerations. Welcome, Professor Rafael Costa. It's an honor for us to have you here today.
I too feel privileged.
Bom, boa tarde a todos. Em primeiro lugar, eu gostaria de agradecer a toda a equipe da Unimar pelo convite, em especial ao John e à professora Mariana, desde já parabenizando-os pela organização do evento e pelo nível dos debates aqui promovidos. Gostaria de dizer que para mim é uma honra poder participar do presente evento, esperando, Jonathan e Mariana, que seja o primeiro de muitos junto à Unimar. Gostaria de cumprimentar também o professor Imtiaz e a professora Maria Helena Diniz, dois grandes mestres de todos nós, e dizer que a minha intervenção ela será breve e dividida em dois pontos principais. Então, agora em inglês. First of all, I would like to thank the whole Unimar team for the invitation, especially to Professor Jonathan and Professor Mariana. Already congratulating you both for organizing the event. I would like also to greet Professor Imtiaz, to say he is a master for us all this afternoon. And moreover, I would like to say that it is an honor for me to be able to participate in this event, and that I hope to be the first of many with Unimar. My speech, Professor, will be brief and divided into two main points or questions. I will speak first in Portuguese for the students to understand, and then I will speak in English, okay? Em primeiro lugar, nós sabemos que o Alcorão é a mais importante fonte da jurisprudência islâmica, sendo, segundo o professor Imtiaz, a segunda, a Sunna. É uma obra que narra a vida e os caminhos do profeta, né? Não é possível praticar o Islão sem consultar ambos os textos. No Common Law, da mesma forma, nós temos encontrado dificuldades na interpretação dos textos legais. A título de exemplo, tem-se observado o surgimento de duas linhas de pensamento, o interpretativismo e o não interpretativismo. Segundo a primeira, os interpretativistas, os juízes devem limitar-se a captar o sentido dos preceitos expressos no texto constitucional. De outro modo, os não interpretativistas entendem que os tribunais podem invocar valores e princípios, tais como a justiça e a ordem, para fundamentar as suas decisões. No direito romano germânico, civil law, nós temos adotado recentemente posições similares, conferindo, contudo, uma nomenclatura distinta para esse mesmo fenômeno que é observado no Common Law. A dúvida que me surge, que eu gostaria de levar à consideração do professor Imtiaz, é a seguinte: quais as estratégias têm sido adotadas pelo direito islâmico para limitar a subjetividade dos intérpretes? Em outras palavras, se o direito islâmico ele tem apresentado alguma forma viável de se buscar a resposta correta, como sugere Ronald Dworkin, ou ele tem admitido de forma pacífica que é possível a apresentação de mais de uma resposta, mais de uma solução para casos similares, na forma sugerida por Gadamer. Professor Imtiaz, in English, the first question that I would like to raise here is, what strategies have been adopted by Islamic law to limit the subjectivity of the interpreter? In other words, does any of the four schools of Islamic law that you have mentioned today present any solution to reduce the liberty of the interpreter? E a segunda questão que eu gostaria de fazer para o professor Imtiaz atenta aqui para os direitos humanos e para os direitos das mulheres. As mulheres costumavam ter mais direitos assegurados pela legislação islâmica do que tinham sobre os sistemas do Ocidente. A título de exemplo, as mulheres há muito mais tempo têm o direito de propriedade no âmbito do direito islâmico do que tem no Ocidente. Muitos organismos internacionais ainda, como, por exemplo, o Tribunal Europeu de Direitos Humanos, consideram as punições prescritas pelo direito islâmico como bárbaras ou até mesmo cruéis e que violariam os direitos humanos. Acadêmicos islâmicos tudo, como já deixou claro aqui o professor Imtiaz, argumentam que, se implementadas de forma correta, essas punições elas servem como meio de intimidação para os criminosos. Ele atenta, portanto, aqui para a função preventiva da pena, né? A mídia internacional tem abordado essa temática com algum destaque e considerando que a lei islâmica acaba sendo muito dura em alguns aspectos, por exemplo, as sentenças acabam sendo mais severas que os padrões estabelecidos internacionalmente para os direitos humanos, né? Como acontece com a aplicação da pena de morte para os crimes de adultério, homossexualidade, apostasia, blasfêmia, a amputações para o caso de crimes de roubo, as chibatadas para a hipótese de embriaguez pública. E aí, em relação a esse ponto, né, em relação a essas considerações, eu queria perguntar ao professor Imtiaz em relação qual é a perspectiva dele acerca da evolução da tutela dos direitos humanos pelo direito islâmico. Se essa tutela dos direitos humanos ela caminha na mesma direção da tutela que tem sido da forma como tem caminhado a tutela no common law e no civil law. Então, then Professor Imtiaz in English, you talked about the harshness of some of the sanctions applied under Islamic law. Considering this, I would like to know your perspective regarding the recent evolution of the protection of human rights under the Islamic law. Does it move in the same direction of the evolution? I would say evolution. I don't know if this is the right expression, because I don't know whether we are evolving or not, but does it move in the same direction as common law and the civil law, or is it moving in a different direction? These were the considerations that I would like to make. Thank you very much for your time and your consideration for my questions.
First, I will thank you for your very interesting and relevant questions. The first, if I can recall rightly, related to the question of the harshness of the Islamic law in certain matters, and to what extent these can be reconciled with human rights as they are evolving. I hope I got that correctly. Okay. Before I come to that, there was one more question which unfortunately I could not hear properly because of certain technical difficulties. Could you please repeat that? I'll be thankful.
Yeah, for sure, Professor. The first question was, what strategies have been adopted by the Islamic law to limit the subjectivity of the interpreter? What I want to know is how to, we have many discussions here about the limits of interpretations. It's like Mariana Diniz proposed the question about hermeneutics. And my doubt is there any answer and solution presented by Islamic law to limit the liberty of the interpreter, or there are no guidelines, no methods to limit the interpretation?
No, it's not that there are no guidelines. There are very well-defined guidelines. I'll refer to some of these. For example, every individual, every person does not have the right to go for an interpretation of the religious law. It is a right only which the scholars of religious law enjoy. The fundamentals were given by the 4 imams, as I mentioned. Then we have the class of the ulama, or the theologians, the scholars of Islamic law. Only they can add further upon the foundations that have been laid. Again, I mentioned that under 3 schools, those of Abu Hanifa, Malik, and Shafi, it is maintained that whatever interpretation was offered, or that was as early as 9th century, that remains firm, that does not change. It cannot be interpreted afresh. Only one school, and that is the school of Imam Hanbal. And of course, if you go to the Shia community also, the school of Imam Jafar, that allows fresh interpretation. In fact, among the Shias, we do have a class of mujtahids who go for ijtihad or interpretation. So we have a situation where there is a rigid stand, where the decisions taken by the three imams is considered final, and we have a parallel view where fresh interpretation is allowed. But in all such cases, the interpretation has to be within the limits or the parameters defined by the Sharia. You cannot alter it, you can only interpret it. Now, to that extent, interpretation depends on your, what would we call, your personal subjectivity, as you mentioned, the element of rationality that you are willing to accept and accommodate. So that would differ. To that extent, the interpreter enjoys freedom. He can apply his own reason. He can take a rational decision, but of course, not beyond the defined parameters. That is why we always say that it is a matter of interpretation. We are not changing or amending it. That is the limit that is imposed. Now, about the question of reconciliation with the human rights under Islam and those in the modern system. Well, in Islam, when we talk about human rights, they are more, I would say, recommendatory in nature. For example, if you come to the question of slaves, now slavery does not exist, but it came to an end much earlier in Europe than in many Islamic lands. Now, in the Islamic lands where slavery continued, and I'm also referring back to the medieval period, the justification, one may or may not agree with it, but the justification that was given was that slaves and even the slave girls or the concubines were actually captives taken in war. Now, the question was how to provide a place for them in society. They could not be left uncared for. So, the system of slavery developed, under which a captive remained as a slave within a particular household, generally of the person to whom he was allotted as a part of the war response. Being a captive, he had no rights as such, and he depended on the treatment that was given by the master. Now, this would differ. Some would be very liberal, others would be very cruel. But if you go by the Islamic injunctions, it was always considered a pious act to release a slave. In fact, some of the penances that are prescribed for certain sins include the liberation of a slave. If a slave is under your custody, you are required, not expected, but required to treat him in a humane and fair manner. That's a different matter that these directives were not always followed. But then that happens with the law also. The law is there and it is violated. So my submission would be that the acceptance or the maintenance of human rights was more of a recommendatory feature in Islamic law rather than a mandatory feature, which it has now become. Again, I would not like to strike a discordant chord, but we know that in spite of the universal rights being accepted the world over, there are serious violations of these rights, not only in situations of war, but also in peaceful, normal situations. So that problem remains. That is one thing. Again, when you come to this question of human rights, unfortunately, I would say, but then there are people who will justify it. I'm not going to that debate. There was a point of time where a clear distinction was made between the ruling elite and the subject people. And the ruling elite enjoyed various rights that were denied to the subject people. If I'm not taking much time, I'll like to cite just two examples. Now, I talked about the Umayyad dynasty, which ruled during the 7th and early half of the 8th century. Now, it was during that period that Islam is spread out from the Arabian Peninsula to neighboring Arab lands. The people were Arabs. But the Umayyad rulers considered the people from the Arabian Peninsula as a superior group compared to those Arabs who lived beyond that area. So important offices, in fact, ranks in the cavalry, matters of exemption and taxation, these were granted to the Arabs belonging to that particular area. Arabs beyond the peninsula did not enjoy the same rights, although Islam speaks of, in fact, it emphasizes on equality of brotherhood of all the Muslims. But that was the situation. Although that concept of universal brotherhood, at least among the members of the community, was always there. It was always emphasized upon. But in matters of actual practice, though that concept of brotherhood was never observed. So there is always a difference between what is preached and what is practiced. And this is not only in Islam, it is there in almost all faiths. So one has to accept that reality, that there is certainly a concept of human rights in Islam. And if you go by the conditions of the 7th, early 8th centuries, I would maintain that these were very noble features of the Sharia. The tragedy is that these were distorted, and unfortunately, even those who now talk of reverting back to the Sharia, they condone these distortions. This is the tragedy. I mean, if one has to return back to the Sharia, go to that particular form of the Sharia, which was liberal, which was humanitarian, which spoke of brotherhood, which rejected exploitation, which rejected the use of intoxicants. Unfortunately, I don't know if I'm being too vocal, but unfortunately, much of the funding of such groups is done through the sale of drugs, those who speak of restoring the Sharia. So that is the difficulty. If we go in theory, the universal law or the humanitarian laws are very much there in Islam, even if they have a limited application for the Muslim community. But even that limited permission has been violated down the centuries. And it has been justified, it has been interpreted, and the rulers and the theologians have all sort of acted in a sort of communion between the two, the communion of their interests. So that is how I would put it. And just one more minute, if I can take your time. I did not refer to another stream in Islam, which is marked by a remarkable feeling of tolerance, peace, brotherhood, a sort of personal communion between man and God, which does not necessarily follow the prescription of the Sharia. I'm referring to the mystic stream or the Sufis. They are a totally different creed. I did not go into that because the orthodox followers of the Sharia would not like to treat them as a separate creed. They have certain reservations about them. So I did not go into that. That could have been controversial. But then we have this facet also, which, I suppose, which is gaining wider publicity, wider popularity in the Western world. When I was at the Khudabakhsh Library, we observed the millennium of Maulana Jalaluddin Rumi, the very renowned Sufi. And we organized certain programs in collaboration with the US consulate. And several international scholars came to the library, and that gave me an opportunity to have an idea of the Western perception of Rumi and his teachings. So these are also images of Islam. These also need attention. The unfortunate part is that if you go to the media or if you go to the popular discussions, the emphasis is invariably on that aspect, which is not only orthodox, but in fact fundamentalist and to some extent aggressive, I would say. The more peaceful, the more assimilative, the more accommodating facet, which can really contribute to what Professor Mariana was just referring to, solidarity among different communities. That, unfortunately, is not given as much consideration as the other part. Let us hope it receives better consideration in the times to come.
Thank you, Professor.
Thank you. I'm thankful to you, gave me an opportunity to take up certain points which I could not cover in the talk. Thank you for that.
Professor Mariana, your microphone is mute.
Thank you for saving the day, Professor Rafael, for the second time. Thank you so much, Professor Imtiaz, for your considerations, and I hope to see you soon in person in our university.
That would be a pleasure indeed.
It will be wonderful, a wonderful opportunity. I told you before that we have a student from doctorate in law that has some experience with Islamic law and questions in general. So I would like to hear Anderson Abraão. Would you like to make some consideration or question to Professor Imtiaz? I think it's important to have you here, Anderson, representing the point of view of the students and giving a little opinion about the situation of how it is to be a student that has some interest in study Islamic law and have no space in academic world.
Muito obrigado, professora Mariana. Eu vou começar pelos agradecimentos em português e, num segundo momento, eu os farei em inglês, agradecendo também ao professor Imtiaz. Né? Então, queria agradecer à Universidade de Marília pela oportunidade, professor Jonathan, a professora Mariana, Santiago, a oportunidade de compor essa transmissão, né, com pessoas de tão elevado calibre como a professora Maria Helena Diniz, o professor Rafael Costa, que me precedeu fazendo uma pergunta tão boa, aliás, todas as perguntas que foram feitas anteriormente sobre a interpretatividade da lei islâmica em conjunto com a nossa legislação, extremamente valorosas. Agora eu farei em inglês, aí, em respeito ao professor Imtiaz. I would like to thank the University of Marília to the opportunity, Professor Jonathan Vita and Professora Mariana Santiago, from the opportunity to compose this transmission. I would like to greet Professor Maria Helena Diniz and Professor Rafael Costa. I will be brief in my considerations. I visited India in 2016. I represented the Brazilian Bar Association in a BRICS legal forum. I'm stayed in MIT University in the city of Noida, near of New Delhi. My family migrated from Syria to Brazil in the beginning of 20th century. Despite my family being of Christian origin, Islamic has always been treated with great respect. Brazil has good relationship with Arab countries, and the professors profess their faith from the Islam. Even they begin in country without an official religion. I understand that Brazil can be a great commercial partner and have a good relation with the Islamic community around the world from respecting all customs. I would like to thank you for all the learning blog, all who watched this broadcast. In your view, now, Professor, if you possible, in your view, how to understand that we can stimulate, improve the relationship between Brazil and Islamic community around the world?
You see, the changing scenario has led to a situation where an interaction among the different countries has become necessary. And even though they pursue different faiths, matters of faith do not come in between the diplomatic relations, economic cooperation, cultural exchanges. In fact, cultural exchanges add to the enrichment of the spirit of tolerance among different communities. So whether we talk about economic collaboration, about diplomatic relations, about cultural interaction, I think these are the new forms, the new media, I would say, that have evolved. And these have promoted a closer relationship, in some cases, closer interaction between different communities. Moreover, we have to appreciate the role of the media, in fact, the social media as well, because that has created a world without boundaries. You can interact with a person from any country, any part of the globe. The media is there. You get information. At times it is misinformation and even disinformation. But then that's not the dominant thing. But you get information. You get information. And of course, you can sort out between the information and the misinformation or the disinformation, whatever you call it. But a rational person can do that. He can sift through this. So our range of understanding has increased. Our economic needs are such that we are now interdependent. So these are the situations where I think certain political barriers, certain barriers artificially created among different communities are going to come down. It may take time, but they are going to come down. And as far as we are concerned, I think we would be, rather it should be, our contribution to help in bringing down, if not breaking, those barriers. So that is how I look at it. And this applies to all countries. It's Brazil and Islamic countries in this particular context. But the same can apply to so many other countries. That is the only way to go ahead. Otherwise, we hardly see a better future for humanity as a whole.
Okay, thank you for your considerations, Professor. Thank you.
Thank you.
Thank you, Professor Imtiaz. Thank you, Anderson. And now I would like to ask to Professor Jonathan Vita if he has some questions or considerations.
No, I really am interested to understand properly, how do you view Islamic law in terms of transnational law? Because actually, since Islamic law is applied in multiple countries at the same time, how can you construe that? Is it regular national law or is it a transnational law? How do you describe this phenomenon within Islamic law? Because I really understand that everyone wants to talk about the punishment and all the different aspects of this Islamic law relating to civil law or even common law. However, the international aspect, I think, is not well addressed within the studies of the scholars on Islamic law. What's your point of view relating to that?
I would like to go into a bit of the past. You see, initially what Islam stood for was the community, the Ummah as they call it in Arabic. And this community was a transnational identity. It transcended national boundaries and frontiers. So all those, again, I'm going to the theoretical position, all those who professed Islam as their faith, whether they lived in one land or another, they were subject to the Sharia. To that extent, it was a transnational law code. As nationalism gained greater strength, 19th century onwards, the situation changed. Politically, the Islamic world was divided into different colonies under different European powers. And these European powers were nation states. National boundaries, national system of governance, law was fundamental to their existence. So they developed that dichotomy between what was the transnational Muslim Sharia, of course for the Muslims, and the new national law or the national legal system that developed under the colonial regimes. Over the years, or over the decades, let me say, with the advancement of the modern state system, these national laws or the laws applicable in particular to a certain country gain precedence. They are more dominant. And so the transnational character of the Sharia is now diluted, if not totally abandoned. In theory, it remains so. If you talk about the punishment for, let's say, murder, or murder is more common, let us talk about theft. Now, theoretically, the position that the hands of a thief are to be cut off is there. It has not been removed, but it is not being practiced except, as we know about the Kingdom of Saudi Arabia. Even there, you will notice that reforms are coming. The very straitjacket interpretation of the Sharia is changing even there. So times are changing, situations are changing, and accordingly, changes are taking place. So to put it more briefly, the transnational character of the Sharia was and is now a thing of the past. It is more a theory than a reality now. And the precedence is always to the national law, because the Muslim countries too are now nation states. You look at the Arab world, there are so many states, even though the Arabs constitute one integral group, linguistically, ethnically as well, geographical region as well. But they're divided into so many countries, each with their national boundaries, which are so strongly protected. So the norm that we have now is nationalism. Of course, we are going to a more universal notion also, the world being a global community, but nationalism still remains in ascendance. So given this situation, the transnational character of the Sharia is no more valid or no more effective. That is how I look at it.
And if I may ask another question, just to
Sure.
fulfill my curiosity, how do you feel about the banking laws in Islamic law? Because we all know that there is a really different legal system pertaining to the rules about interest and, you know, the complexity of the financial arrangements in the Islamic world. I believe it's interesting to let our viewers know something about that.
I mentioned that very briefly, just one sentence, but it is good that you are giving me a chance to speak about that in some more detail. See, usury and interest are often treated as two separate categories by some law givers. Usury implies some sort of an exploitation. I mean, you take advantage of a person who is in need of money, you extend a loan, you impose a very heavy rate of interest, which ultimately leads to the perpetual poverty of that man, the man who has taken the debt. So this oppressive, exploitative nature of the interest is what they define as usury. Interest which comes to you through the banking system, which does not involve any direct interaction between the giver and the taker, which does not have an exploitative character as far as the two are concerned, that many scholars believe is permissible. Now, I can't go into the sort of correctness of either of the views because I'm not a religious scholar, as I said. I'm just presenting the position. Now, in some countries, there has been an attempt to introduce the concept of interest-free banking. It has been implemented. But if you go deeper into it, you cannot have an economy which does not base itself on interest. Commerce, mercantile activity naturally generates profit. In Islam, again, there is a provision for profit. Profit sharing is banned, but profit is there. I'm forgetting the exact injunction of the Quran, but it is something to this effect that God has prohibited usury but allowed profit. And as you know, the Arabs were good traders even in the pre-Islamic period. So for them, trade and the profit earned from trade was an integral part of their economy. In fact, some of the early battles that were fought between the Muslim and the non-Muslim Arabs was due to this desire to control the trade route. So coming back to what I was saying, interest-free banking is an attempt, at best an experiment. The ultimate result of which is still too hazy. Going by the logic of the situation, I cannot think of a place of any economy where you can live entirely without generating profit and that profit being transferred indirectly as interest through the banking system. Most of the countries follow it. The quote-unquote Islamic banking, based on the absence of interest, is, as I just said, essentially an experiment. It has found acceptance only in a few areas, few countries.
Thank you so much, Professor. I think this is the end of our event, so I would like to thank you again, and I would like to say thank you to all the professors and the students that are together today, and especially to you, Professor Imtiaz. I think, thank you for being who you are, this person so special and so generous. I think your presence here today will enlighten many young people to study about Islamic law without any prejudice, and I think it's so important. I think we can use the university in this fight. I think it's our duty as professors, so I'm very, very glad for you coming, and you are invited to be in person in future, if it's possible, when it's possible, besides the pandemic. Let's try to make it work, and thank you once again. Em português now, eu queria agradecer também aos alunos que estiveram com a gente hoje, e que demonstraram tanto interesse pelo tema. O tema é tão relevante para o nosso curso, que fala de desenvolvimento, que fala de mudança social. É uma lição sobre tolerância, é uma lição sobre essa solidariedade, sobre cultura, um assunto pouco explorado no Brasil. Eu finalmente consegui achar o professor Rafael e o Anderson, a professora Maria Helena Diniz, que se dispuseram a ajudar, mas não foi tão simples assim encontrar especialistas que com domínio do idioma para discutirem esse assunto com o professor Imtiaz, que é uma sumidade reconhecida internacionalmente nessa temática. Eu espero que isso gere frutos para nós. Eu sei que tem outros alunos, outros grupos de alunos muçulmanos nos assistindo hoje, além dos alunos que normalmente nos assistem de norte a sul do país. Eu realmente fico grata pela possibilidade de ver isso acontecer e espero que o professor ficará certamente à nossa disposição para que nós possamos formar aí grupos de estudo e aprofundar, né, a análise aí dessa temática, né, já que nós estamos aí falando para alunos de doutorado que estão sempre em busca de originalidade, novas temáticas, ainda não tanto inexploradas. Acho que é uma oportunidade de ouro para que a gente construa aí um grupo de estudos e publique material sobre esse assunto, já que no Brasil há uma carência, né, sobre isso, que me pareceu agora nas últimas semanas muito evidente. De qualquer forma, agradeço a todos, não se faz internacionalização sem a presença dos alunos. Semana que vem estaremos de volta, discutindo aí mais um tema de direito constitucional sobre liberdade de expressão, com um grande amigo argentino e outros professores brasileiros também muito especiais. Seguimos aí, né? O ano está quase acabando e eu agradeço a vocês por estarem tantas semanas seguidas aí prestigiando o nosso evento. Eu aguardo vocês na semana que vem. Um grande abraço a todos. Encerrando a transmissão, até semana que vem.